Hi, everybody. Thanks for joining this month's NAA webinar. We really appreciate the strong turnout online. And if you're watching it after the fact, thanks for tuning in as well. So all of NAA webinars are recorded. So just a little housekeeping, and then we'll turn it over to our guest this month. My name's Charlie Culpepper. I'm the Director of Membership and Public Outreach for the National Aquaculture Association, and happy to run our recurring webinar series that we have. Um, Before I turn it over to Andrew, just a little housekeeping. Everybody's set to mute, no video cameras right now. But feel free if you have any questions or anything like that. We'll be monitoring the chat the whole time. And yes, there will be a recording that's available later as well. So look for that to be released really soon, probably tomorrow after the recording's all set up. And it'll be posted on our YouTube channel as well. So if you do have questions, type them in the chat anytime. Once Andrew wraps up, we are going to open it up for a Q&A session. So at that point, you can use the raise your hand feature. I'll take you off mute, no problem, and you can speak up directly, or again, you can use the Q&A. So either option works. So each webinar, we do have a sponsor that kind of supports this NA webinar series that we have. So just want to give a shout out to Aquatic Equipment and Design. You'll see their logo and contact information on my Zoom background. Aquatic Equipment and Design offers design and training services and a full log of aquaculture equipment. So please, they reach out to them if you're in the aquaculture or aquaponics sector. They'd be happy to speak with you and help you out. And thanks again to them for sponsoring this month. With that, I'd like to introduce our speaker, Andrew Choi. He is a partner in the healthcare practice with more than a decade of experience litigating on behalf of the U.S. Department of Health and Human Services Office of General Counsel for the Centers for Medicare and Medicaid Services Division. Andrew is based out of Washington, D.C. He's a veteran litigator with unique experience in healthcare law, Medicare, administrative litigation, and regulatory compliance. In his role with the Department of Health and Human Services, he represented the Centers for Medicare and Medicaid Services Division in a lot of high-stakes legal challenges involving Medicare, Medicaid, and the Affordable Care Act, and other healthcare programs. His litigation strategy and acumen contributed to saving the Medicare program hundreds of millions of dollars, experience he now leverages to protect and recover provider revenues in private practice. Having defended agency rulemaking and advised federal agencies on other regulatory enforcement matters, Andrew's deep understanding of healthcare laws within the framework of the Federal Administrative Procedures Act informs his approach to providing clients in the healthcare and life sciences industry with efficient, precise, and strategic approaches to their most critical business needs. Andrew has counseled a wide variety of healthcare, food and drug, and life sciences company at his current practice with Arnold, Golden, and Gregory, one of the largest international law firms in the world. At Arnold, Golden, and Gregory, he focuses primarily on representing hospitals, health systems, laboratories, and suppliers in transaction, direct reimbursement litigation, appeals, and government audits and investigations. So as a trusted leader in the healthcare industry and legal practice, Andrew frequently speaks on critical issues affecting regulated entities under HHS, including FDA and CMS. He also serves as an adjunct professor of health law at NYU's Wagner Graduate School of Public Service and is presently a member of the UNC Board of Advisors. So, Andrew, we really appreciate you taking the time out of your busy schedule to provide us some legal insights into the post-Chevron world. It's definitely an exciting topic that the aquaculture industry has been following, and it's great to have you here and to listen to your expertise for a little while. So, with that, I'll turn it over. You're free to start your presentation.
Thanks, Charlie. And I'll say that if anybody's scratching their head about why a healthcare lawyer is talking about fish, hopefully this presentation will shed light on precisely why that's the case. So I appreciate everybody joining today, and I'll try to leave some time at the end. But I think there's been a lot of ink spilled about this post-Chevron world and why it is that this seemingly remote and niche litigation about a commercial fishing vessel has arguably upended about 40 years of administrative law, which will affect all federal agencies and their regulations and any challenges to those regulations going forward. And it doesn't matter what regulated industry we're talking about. So it can affect healthcare, it can affect um, um, fishing, it can affect aquaculture, it can affect the environment. So, um, you know, I like to say that in over a decade's worth of defending a federal agency, I lost two cases, and that wasn't because I was some rock star litigator. No matter what I tell myself, it was because I had Chevron behind me, and that created a level of agency deference that was very difficult to surmount for plaintiffs. Now that Chevron's been overturned, we have a very, very different posture for the regulated entities and their relationship with federal regulators. And I characterize that as a litigation-driven regulatory environment. So it's been very destabilized post-Chevron. And, this was an earthquake that occurred in uh, June of last year that I, I ask whether who it is that felt the earthquake. Um, just to be clear, this is an area of law that is decidedly the most unsexy type of law one could practice, but it was an earthquake and has really, really profound implications for regulated industry. And so I hope that folks will understand at the conclusion of this little webinar what the significance is, I think, for aquaculture, but also what the significance is for the entire nation. So I'll just jump right into this. Pardon me, I've got an agenda here. We're going to start with like a little civics refresher. We're going to then turn over to the Administrative Procedure Act itself. We'll talk about the case Chevron um, as it was originally decided. And then we're going to talk about the case that overturned Chevron called Loper Bright v. Raimondo. Um, and then we'll talk a little bit about the laws regulating the aquaculture industry generally. And then I'll end with what I hope folks will understand as these new business competencies in the post-Chevron world. So forgive me for insulting anyone who's hasn't forgotten their high school civics, but let's just like start with some baseline understanding. So we have three branches of government in the US. And so we have the legislative branch, the judicial branch, and the executive branch. And they all have a way of creating laws, right? But the type of law differs based on which branch is producing them. So in the legislative branch, which is Congress, they're passing what are called general statutes, right? So this is something like the Clean Water Act, and it's general in nature. Um, the executive branch is tasked with creating regulations. So that's also a law, but these are a species of law that only comes out of the executive branch. And then, of course, we have the judicial branch, which issues opinions. Those are a different type of law. So three different branches, three different types of laws. But we're going to focus in on specifically the legislative branch and the executive branch here. And the executive branch is really tasked with only the execution and enforcement of the laws created by Congress, which means that the executive branch is effectively subordinate to the legislative branch. They have to execute and enforce what's already prescribed under the legislative branch or what Congress has already spoken to. And these, of course, are the regulations themselves. So how is it then that you have this constellation of federal agencies within the executive branch that get to interpret these uh, general statutes that are written by Congress. And by that, I mean, in our sort of representative form of democracy, um, members of Congress are elected. So we have bestowed certain lawmaking rights to them. But if you're unelected and you're in the executive branch and you work for one of these federal agencies, where is it that they sort of get empowered to write regulations or laws? And so the answer is enshrined in something called the Administrative Procedure Act, and I'm going to refer to this as the APA. And Senator Pat McCarran characterized this as a Bill of Rights for the hundreds of thousands of Americans whose affairs are controlled or regulated by federal agencies. And so that little star over there is right over Senator Pat McCarran at the signing of the APA. And I think about the APA as regulating the regulators. So it's sort of like an oversight statute that makes sure that to the extent that we are going to allow federal agencies to regulate as unelected officials, there needs to be some layer of regulation for these agencies themselves, and that's the APA. And so there's sort of these four general principles in the APA. And the first is that the APA requires agencies to keep the public informed of the agency's organization and the procedures and the rules that these agencies are going to abide by. The APA also provides for public participation in the rulemaking process. So that's public comment. In other words, the public is part of the federal agency's rulemaking authority in the first place. Federal agencies necessarily take in input from the regulated community. The third is that the APA establishes these uniform standards for how it is that the public is going to participate in the rulemaking process. So in other words, it has to be predictable. And then finally, the APA defines the scope of judicial review. So to the extent an agency may, let's say, color outside the lines, there's a standard of review, and it's known as arbitrary and capricious review, to make sure that a federal agency is abiding by exactly what the limited scope of authority is as non-elected officials to interpret these general statutes that come down from Congress. So in 1984, the Supreme Court defined this scope of judicial review in something called the Chevron doctrine. So this was almost exactly 4 decades ago. And there was this case, it was called Chevron USA v. Natural Resources Defense Council, that involved a challenge to the EPA's interpretation of a provision in the Clean Air Act. So the Clean Air Act was a piece of legislation that was enacted by Congress. And again, you've got a federal agency, the EPA, gets to interpret that piece of that provision in a federal statute. And the argument from the plaintiffs, the Natural Resources Defense Council, was that the EPA had unlawfully changed the definition of a stationary source that effectively allowed for more flexible air pollution controls than what the plaintiffs believed that Congress had intended. In other words, the plaintiffs thought that the EPA had gone rogue. They had exercised more authority than what Congress had originally intended. And so what the Supreme Court did in 1984 was they established this Chevron doctrine that is, in effect, 2 steps. So the first question for the Supreme Court is, did Congress clearly address the issue? In other words, does the plain language of the statute resolve the question before the court? And if not, then was the agency's interpretation of the plain language reasonable? Now, if it's reasonable, then the courts are going to defer. And this term defer is a legal term of art that effectively means that the court is going to back off. It's going to defer to the agency's expertise. And when you have a federal agency that's supposed to be expert, they're supposed to be folks that are experts in industry or experts in science, then the court is going to say, we'll back off as long as your interpretation of the congressional statute was reasonable. That deference created about 40 years of what we call the Chevron era. And over the course of this Chevron era, we had approximately 438 federal agencies and sub-agencies that were given this level of deference. It's this expectation that certain types of knowledge or certain types of expertise is housed in these federal agencies, and courts are not going to second guess reasonable interpretations from these agencies of the authorizing statute. Now, oops, sorry. A few years ago, that all changed. And, excuse me, in a case called Loper Bright, I love this quote that came out of one of the opening briefs. The plaintiff said the government has, without congressional authorization, erected a new office and sent hither swarms of officers to harass plaintiffs and eat out their substance. I love this quote because it tells you that we're talking about commercial fishermen, who oftentimes sound a lot like pirates in their briefs. And in this case, we had a situation where a federal agency was being tasked with interpreting the language of the Magnuson-Stevens Act, and I'm going to refer to that as the MSA. So what happened was the Magnuson-Stevens Act had required that fishing vessels pay observation fees under three circumstances. One, foreign fishing vessels. Two, limited access fishing vessels. And three, North Pacific fishing vessels. So these observation fees are only required in these three circumstances. Now, at the same time, there's another part of the MSA that says, overall, conservation and management measures like observation fees that are necessary and appropriate to prevent overfishing and rebuild overfished stocks and to protect, restore, and promote the long-term health and stability of the fishery. There's this necessary and proper intention, also enshrined in the Magnuson-Stevens Act, and taken together, all together, right? We're creating this sort of congressional intent that the National Marine Fisheries Service is designed to construe. But of course, we have a situation where the Loper Bright fishing vessel is located off the coast of New England. So it's not a foreign fishing vessel. It's not a limited access fishing vessel. And it's not in the North Pacific. So in other words, the statute is saying these observation fees are required for these three categories. NMFS is actually applying that here. They're requiring this Atlantic fishing vessel to pay the observation fees. And yet, this boat doesn't actually satisfy those requirements. And so the idea was that because there's this other part of the MSA that has this broader language about where it's necessary and appropriate, the agency could sort of reasonably interpret that what the MSA really meant was that it would be applied nationally. That 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 under this necessary and appropriate language, even though there's another part of the statute that only really requires observation fees for these three categories, they could sort of get this Chevron deference, right? That the agency is afforded expertise and deference. And so because there's this ambiguity, because while the three requirements may not be met, if there's this necessary and appropriate language, that's enough of an ambiguity where the court should back off. And that was the argument made by the government under the Chevron doctrine that had been in place for 40 years. The Supreme Court said no. And in fact, they overruled Chevron and stated very explicitly that the courts will no longer automatically defer to agencies whose rules and regulations are challenged, and they will not back off. And instead, courts individually will analyze independently. And what that means is they will apply the judicial review provisions of the APA, the arbitrary and capricious review, on a case-by-case basis. There's no longer this automatic deference that's afforded to agencies. That was the earthquake. That one decision, which may have contemplated a simple case of some Atlantic fishing vessels, has changed the course of American history for a very, very long time. I think it's safe to say that what this means for all regulated industries is a great deal of instability. And to the extent aquaculture and the seafood industry are also regulated industries, that means there will also be instability in the aquaculture industry. So then let's talk a little bit about who are the federal agencies that regulate aquaculture. So of course, we have NOAA. NOAA is tasked with carrying out and interpreting the provisions of the MSA. I'm sure it's lost on no one here that the MSA requires fishery management plans that also that in some cases include aquaculture. NOAA also carries out provisions of the Endangered Species Act. So sections 1531 to 1544 have provisions that require that aquaculture doesn't harm endangered marine species. The U.S. Army Corps of Engineers carry out the provisions of the Clean Water Act that have to do with discharge from aquaculture operations, the Rivers and Harbors Act of 1899. And hopefully what you're seeing here in this table is that you've got this authorizing statute, and then you have the agency over on the left that is interpreting the provisions of the congressional statute. And here are the little parts where aquaculture can fit in. We also have the Lacey Act that's being that tasks the U.S. Fish and Wildlife Service with regulating the import and the export and the transport of fish and wildlife, which includes aquaculture species. We have the FDA that carries out the FD&C Act that has to do with seafood safety. Aquaculture is part of seafood safety. The Public Health Service Act also bestows authority to the FDA to oversee foodborne disease and prevention related to aquaculture. So you can see where aquaculture actually comes into play through these federal agencies that are interpreting federal statutes, and there's a variety of federal statutes at issue. So post-Chevron, I think the question is, what are aquaculture companies supposed to take away from that decision? Like, so now what? Is this just kind of something that lawyers are supposed to figure out? And I would argue, as much as that maybe used to be the case, I don't think that's true anymore. I think that there are new business competencies that are incumbent on all businesses operating in regulated spaces today to make sure that they understand what the significance is of this post-Chevron world for their businesses. So, for example, um, aquaculture companies now have more opportunities to challenge burdensome regulations directly. That also means that environmental groups can challenge burdensome or the regulations that they feel are burdensome directly. That also means that judges are going to interpret the underlying statutory language independently from one another. And so what that means is that we are here now in a very litigation-driven regulatory environment. That means that we're going to have less predictable regulatory outcomes for the industry overall. And we're already seeing that in the healthcare industry. We're seeing that in natural resources industry. It's very unstable. That's because for so long, a lot of businesses have relied, and agencies too have relied on these interpretations to sort of define these very hallowed compliance requirements nationwide. But absent that level of deference, we have already conflicting judicial interpretations. We have circuit court splits. I don't want to get too nerdy about the legalese. But now what we have is a very fractured system where, because we have no longer this Chevron deference to rely upon, and we have a much more open opportunity for various interests and stakeholders in the regulated industries to challenge these federal agency regulations. And because we have, of course, a lot of different courts that are and judges that are going to come out in different ways, there's a lot of fracture and there's a lot of instability. And the reason I think this is a business competency is because competitors to your own business could challenge a federal regulation that, if they overturn a federal regulation, it's going to benefit their interests. And so any regulated industry that's composed of a variety of stakeholders that may have once relied on a certain type of regulatory environment now could be facing competitors, and it's already happening. I don't know why I'm using the present tense or the future tense. It's already happening. You have now competitive industry within a regulated environment that are challenging federal regulations and creating new environments that are beneficial to them and only them. So this is creating instability in a wide variety of markets. And that means that leadership in these regulated industries need to actually increase their legal competencies. This doesn't necessarily mean that you have to run out and start hiring a bunch of lawyers, but it does mean that you need to be familiar with what these court decisions coming out with that may benefit your competitor. You're going to need to be in the know about where it is that you need to actually challenge some of these federal agency interpretations. And then you're going to need to get compliant if a regulation is overturned or if a regulation goes forward. You're going to need to be in tune with what those dynamic new environments of new decisions coming down from federal district courts mean for your business. Really importantly, you're going to need to participate in notice and comment rulemaking in a way that maybe, I think, especially in seafood, aquaculture, and fishing, I think there's been a little bit of a lackadaisical approach in industry overall to a lot of the notice and comment opportunities historically. That can't happen anymore. Today, the participation in notice and comment rulemaking is absolutely critical. That's because to the extent challenges take place in federal courts, there is no discovery. So what a court is tasked with reviewing is the record of public comments that come in. Um, so making sure that you raise your voices in the notice and comment process is absolutely critical going forward. If you have questions about how to submit notice and comment, I'm more than happy to take those um, later. But for what it's worth, when you submit a public comment, the federal agency under the APA is required to respond to relevant comments in the preamble of any final federal rules. Um, Also, I think it's incumbent on stakeholders to make sure that to the extent there are interests being represented, either on the plaintiff side or on the defense side, um, that will affect your industry, that you understand how to participate as amicus. So if there's an issue that's being litigated that will have an impact on how you do business going forward, you need to be a participant even in the litigation. Um, I think also there needs to be an increased level of legislative advocacy in Congress, but I'll qualify that by saying I think historically, the effort to lobby Congress for particular interests have been specific for outcomes. There's a specific outcome that you want from Congress. I think today or I know that today it's a little bit different. Legislative advocacy efforts are oftentimes couched in terms of regulatory stability, not necessarily specific outcomes. And because the litigation driven environment is very that in and of itself is quite burdensome. So I think the landscape has changed, game has changed, Washington, D.C. has changed. This new presidential administration is also changing things. Um, we will see how the APA holds up going forward. Um, but there are a great deal of interest in every single regulated industry that are being ventilated right now through Congress, through the courts. I'm sure people are paying attention to everything from immigration to deportations to challenges to the reductions in force. All of them have an APA component to them. And so I hope you all feel a little bit better about maybe some of the things that you might read in the newspaper about these APA issues that are being litigated as we speak. That is reflective of sort of the balance of and the separation of powers in the United States right now. And that has to do with the way that we task federal agencies with carrying out the rule of law as articulated by our elected officials in Congress. So I'll end it there. If there's any questions, uh, please feel free to ask them now, and I'll try to do my best to answer them.
Andrew, thanks so much. Fascinating presentation. So folks, yeah, feel free to raise your hand. Now's the chance. You get to speak with a veteran litigator here. So you've got his open ear. Please drop them in the chat box or raise your hand if you have questions. Got a good audience here. I can't believe no one has any questions. I've got a couple. So, oh, there we go. Caitlin, hold on one second. You should be able to unmute now.
Great. That was great, Andrew. I have a question relating to, I know when when Chevron was first overturned, from the congressional side, there was a bit of concern over like the other side is if you're having regulations, the legislators would have to pass much more specific legislation. Um, and how do you think that concern kind of ties in with the need for kind of adapting legislative advocacy if there might be an expectation on legislators to craft legislation that's much more explicit to try and kind of overcome
Yeah.
um, the overturning of Chevron?
Um, it's a fascinating question. So let me try to answer it um, in a way that I hope is sensitive to maybe where we're at politically. So first, let me try to paraphrase the question. So I think what you're asking is whether or not Congress can try to help the agencies avoid some of these challenges by crafting the underlying statute in a way that isn't so open to ambiguity and therefore open to challenge. And I think it's lost on no one that the quality of bills and legislation that has been passed in the last, let's say, 20 years hasn't been great. Um, we know that because we have agencies like the FDA who have come out explicitly in guidance documents and said, we actually don't know what Congress meant here. And so we're going to do our best to interpret it. But hey, Congress, could you just like tighten it up a little bit? Like tighten this up because you're creating a situation where we're actually quite vulnerable to challenge. And frankly, industry needs to have better guidance. So I think the answer to that is I don't know. You are hitting on something that I think is like a very fraught subject, and it has to do with the quality of legislation that comes out of Congress today, which is in many cases troubling. I also think that if we talk about like the language, the English language itself, one of the things that keeps lawyers like me employed is figuring out ways to make arguments that language just by definition is ambiguous. Um, and it's hard to think of circumstances where you can actually create really, really airtight language that has absolutely zero opportunity to be ambiguous. Um, so I hope I'm answering that question. You're right that there are there have been a lot of there's been a lot of money spent on trying to tighten the language or even amend statutory language to make it more clear and therefore less subject to the ambiguous argument. Um, I think there's like swings and misses on that. Um, but that will never not be a problem. Um, but if you're asking if there are opportunities to go to Congress through lobbyists, ask them to pass amendments to tighten language, I think that's absolutely a worthwhile exercise. Looks like Paul's got a question.
Andrew, thank you for your great presentation. I had to step out for a phone call, so I'm gonna have to watch the recording. But this what I could hear was really, really good. And my question is, um, we, the NAA, through committee work, have commented on quite a few proposed rules. And typically, we just focus on the language in the Federal Register, what the agency is saying. But what I'm hearing you say is we should really be reading the U.S. code and sort of comparing that to what the agency is now proposing as rule, which really amps up the effort that would have to be made.
Okay, so I'm hearing two things, and I appreciate this question very much because this is a question that I get a lot from my own clients. So the first question is about the public comments themselves. And then the second, I think, is about really scrutinizing whether or not regulations line up with what the underlying statutory authority was in the first place. So let me try to answer the first question. Public comments, there's a procedural component under the APA to how the agency must respond to public comments. And then there's also a substantive component to how the agency must respond to the public comment. So as a procedural matter, for example, let's say you submit a public comment and the federal agency loses it, like literally loses it. There have been many, in fact, I've had to defend those types of challenges in the past before the digital age, but like it was not uncommon for a federal agency to lose a public comment. And so as a procedural matter, they ran afoul of the APA, and literally the regulation could be struck because the federal agency failed to, as a procedural matter, even consider the public comment that came in from a stakeholder in the industry. Substantively, if let's say a member of a regulated industry were to submit a public comment that raised an issue that the agency hadn't thought of before, and the agency did a really bad job of responding to that public comment, and as a consequence ignored it, the agency has litigation risk. That comment, that regulation could be struck on that basis. If, let's say, a public commenter submitted a public comment that said, we don't like this approach, like it's not our favorite way, and the agency says, yeah, well, too bad. That public comment actually will be summarily dismissed, and as a legal matter, the agency is not required to consider it. The standard is whether or not the agency's approach was arbitrary and capricious. So if your public comment is just saying, well, this is our favorite way, I wouldn't recommend that going forward. Instead, public comment needs to actually create litigation risk for the agency. In other words, like, if the agency were to be challenged going final in the rule, will a judge look at how they crafted the rule and say, well, hold on, like there was a public comment here that said, this statute does not say what you think it says. And if a public comment were to call that out, then you're creating risk for the agency, and that's a much more effective public comment. Does that make sense? So, you know, there's no shortage of public comments. There are thousands, especially in different industries, that come in during the proposed rulemaking phase, where members of industry will sort of raise their voices and say, you know, we don't like this, or we like this, or we don't like that. And those don't necessarily carry a ton of legal weight. And so it's hard to move the agency on those grounds because that's not the legal standard. But if you were to bring a public comment to a federal agency that is invoking the legal standard and also disabusing the agency of taking a particular approach because they would violate the legal standard if they went final, that is an effective public comment. That is a public comment that can actually move the agency in a way that is creating legal risk for the agency. And that's sort of the trick of administrative law. It's, do the public comments create litigation risk for the agency? And litigation risk, by the way, you know, maybe I should have said this before, a federal agency that's challenged. So like in the case of the Loper Bright case. So what happens when a plaintiff, quote unquote, wins in an APA lawsuit? It's not like a win if you're in a car accident. This is not tort law. This is administrative law. So the answer is that the remedy, the win, is something called a remand. It's mandamus relief. So that means that the federal court will strike the agency's action. There's no money exchanged. There's no one's going to prison. That's not the relief under the APA. The relief available under the APA is that the federal agency's regulation can be struck down. Does that answer your question, Paul?
Yes, it did. And of course, it sparks another question, but I'm afraid of taking too much time here. The second part of it is we have always looked at those Federal Register notices and examined what the agencies were proposing to do and responded to that. And rarely, although recently we've done this, gone back to the U.S. Code and actually look at their authority. And this has really amped up the effort. And from what I could get from your presentation, this is actually how we should act going forward as an association, is not just the proposed rule, but the underlying U.S. code, do that kind of analysis as well.
That's 100% right. That's exactly right. I think about it as sort of looking under the hood. So I think it's easy to take as gospel what a federal agency is saying, because I think a lot of regulated industry, they just sort of assume that federal agencies are the word of God. The problem is that they're not under our representative form of democracy. Federal agencies are composed of individuals that are not elected. And so if they're not elected, then that should immediately beg the question, like, well, then where do they derive this authority under our American system of democracy? And if they're not elected, then you've got to go a little bit further and say, okay, well, where did the elected officials speak? And that is, to your point, in the underlying statute. So the question is, again, what you just said, what does the actual original statute say? And does the proposal in the Federal Register track with the intent of what the original statute says? And that's exactly what happened in Loper Bright. When they went and looked under the hood, they found that the MSA actually has requirements that don't apply. They like literally did not apply to a herring fishing boat operating off the coast of New England.
Mhm.
Nothing in the MSA said that.
Yeah. So, if in the case where an agency has approved, well, they proposed their regulations some time ago, let's say several decades ago. This is an actual instance. And they have been rolling forward with regulations, and suddenly a stakeholder group like ourselves wakes up and notices they don't have the authority, and says, you don't possess the authority for this, as well as not approving this rule. Does the agency, and so these are comments we really made, we need you to unravel prior regulations as well. Will they do that, or do we have to actually go to court and bring a legal challenge?
Well, okay, this is a fascinating question because it implicates a second Supreme Court case that was decided last summer that I didn't touch on today. But since you raised it, we'll go there. There was another case that was decided in last year's Supreme Court term called Corner Post. And it has to do with the statute of limitations available to an agency. In other words, let's say an agency fixed or went final with a regulation in the year 2000. How much further in time can a potential plaintiff come back and challenge that regulation, which I think is your question. So that case is called Corner Post. Under Corner Post, so under the APA, and reasonable minds can differ about this, there was a statute of limitations of 6 years. So in other words, if the agency went final with the regulation in the year 2000, there were it was until 2026 that a plaintiff could come back and challenge that regulation, the underlying lawfulness of the regulation. That had been the world for a long time. Corner Post said, no, it's not 6 years. Corner Post said, it's 6 years from the date of injury. 6 years from the date of injury. So that means that if a regulation went final in 2000, and there is someone that is injured in 2025, you could challenge that regulation. Now, let's say the plaintiff was around in 2003, and they didn't, then the statute has run. But let's say that it's a new company. They didn't come online until 2025, and now they're injured by this unlawful regulation. Corner Post says you can challenge it. Now, getting to your question about the NAA, it's a little bit trickier because as a named plaintiff, there's going to be standing issues. So you have associational standing as the trade association overall, but it's going to be a little bit tricky to navigate the statute of limitations as an organization, as opposed to an individual plaintiff that may have been harmed within 6 years. We can talk about that offline, but I hope that answers your question. Maybe, there were maybe 2 cases that are important for your question.
No, thank you very much. It did, and I want to defer. There's some questions in the chat, and we don't want to miss those. Thank you to Andrew.
Sure.
All right, Andrew, I'll read you off. Yeah, we had 2 great ones come in the chat box as well. So you mentioned, in this era of instability now, do you see that this could possibly slow down new aquaculture projects or permitting if litigation becomes a more frequent part of the process for NOAA, Army Corps, or other federal agencies making interpretations?
100%. It's happening in a lot of different industries. The risk of let me back up a little bit. So I was talking a little bit about the remedy. So what happens when an agency loses? So if a regulation is struck, then the agency doesn't then just say, okay, well, then that's just off the books. The agency actually has to go back and redo that regulation. They need to make it conform to what the original intent of the statute was. And that is a major lift for a federal agency to undertake. To actually to go through the process of notice and comment rulemaking, that's not something that happens for free. It's something that you have to dedicate personnel to. It's something that requires literally taxpayer money. It requires sometimes an appropriation. So agencies don't want to have to go back and redo regulations. So when you have circumstances like what you're describing here, where you have potentially aquaculture projects that require some sort of regulatory oversight, that require some sort of regulatory stability, and let's say you've got plaintiffs that aren't allowing that regulatory stability to occur because they're challenging agency rules and regulations, then yes, you can have projects that get held up potentially while litigation takes place. And then, of course, for the correction um, that the agency might need to undertake? Yeah, absolutely. That's exactly what's happening in a wide variety of industries right now. Everything from gaming, federal gaming leases to healthcare to aquaculture to fisheries. This is sort of where we're at as a national posture.
Okay, and I think we'll do just one more question, unless anyone has a final one after this one. Just so, do you think that the post-Chevron doctrine world, will this trickle down to how states interpret state issues and laws?
Man, I was hoping no one was going to ask this question. Um, so this is a federalist question, and to be clear, the Administrative Procedure Act is effectively mirrored in every state. Like every state has a version of their own Administrative Procedure Act. So of course, like every state has a Secretary of State. Every state has the equivalent of like a Department of Natural Resources or whatever that state may call it, which means that all states also have these state agencies. And state agencies, again, like federal agencies, are composed of non-elected officials, but that are answerable to the state legislature. So you have sort of this mirror of like state, the three branches in a state government and the three branches in the federal government. The doctrine of Chevron deference was not uniformly adopted in all states. A lot of states have their version of it. So New York, for example, has a similar kind of concept of like this, or had a similar kind of concept, this two-step Chevron deference cadence. Other states never really adopted Chevron in the same way, or maybe adopted like sort of the plain language component, but not the reasonableness standard. So it does vary. I hope I'm not being too squirrely by saying that states are kind of in a weird place. Some states are in a weird place now, trying to square the loss of Chevron deference with their own state laws. So to the extent there's a litigation that only really implicates a state agency as opposed to a federal agency, there's going to be new laws over the next, I don't know, maybe another 4 decades, where state courts are going to have to grapple with some of these issues. But that's a really, really good question.
All right, Angel. We're at 2 o'clock Central Time, so yeah, I think we'll wrap it up there. Really appreciate you spending the time. This is a fascinating topic, and yeah, with that, I would just let everybody know stay tuned for the announcement. We've got a May 14th will be our next webinar. We've got Robert Smith returning from K&L Gates. He's going to be talking about litigation strategies for businesses. So. Again, thanks so much for tuning in to our NAA webinars. Please consider joining us if you're not already a member, so you can get in the loop with everything going on at the national level. And I hope everybody has a great rest of your day. We'll see you next time.
Everyone.